In a room where truth battles excuses, every heartbeat echoes under the judge's gaze. From apologies to second chances, from pleas to justice. This is not just another day in court. It's a fight for freedom, faith, and redemption.
The people, they just need an opportunity to review that properly. Could have an adjournment.
Probable cause conference will be adjourned until November 25th, 2025, 9 a.m. That is a Tuesday.
Tuesday.
Bond will continue. Thank you.
Yeah. 11:05. Okay.
Court does call the case People versus Robert Barnett. 3 cases.
Assistant Public Defender Sandra White on behalf of Robert Barnett.
Your name, sir? Robert Barnett.
And Your Honor, we were here before and we have identified that 2 of these cases are duplicates, so it's going to be newly filed. I'll have the case number for you here in just a moment. I apologize for the delay. But other than that, I think we are currently looking at an adjournment for today's matters.
That is correct, Your Honor. We are asking for an adjournment. On one of the cases, 25 F5 5793, we are still looking for media on that case.
On 5793?
Yes, we're still asking for body cams or any available videos.
Okay.
And the other one, I have 2 case numbers because I'm not sure which one is going to be dismissed.
Right. No, I got you. So, but you're ultimately looking for an adjournment on both of the ones that remain.
That's correct, Your Honor. And if I may address bond.
Hang on one moment. Let me make sure my paperwork is right.
In the quiet tension of the courtroom, one voice breaks through. Man, I'm sorry. But apologies don't stop justice. The defense pleads for time, asking for adjournment, while the judge's calendar decides their fate. Every word feels heavy, every silence louder than the gavel. Justice may wait, but it never forgets.
Is it gonna really matter?
Ultimately, I think it's going to be the, oh my gosh, I think it ended up being the 24FB1406.
That will be dismissed?
Yes.
Okay.
I believe that one, it will be on the paper, but I do think it will be that case.
The 1406?
Yes.
Okay. And I'm assuming there's no objection to the dismissal?
No, Your Honor.
Right. So
No objection.
I'll mark that one as is. If there's some reason that's not it, then we'll deal with that. All right. And then the other case, I will adjourn to that same date of November 20th.
Thank you, Your Honor.
And then as to bound.
Yes, Your Honor. I do believe it was addressed at the last hearing, but Mr. Barnett wants this court to know that he will abide by all bond conditions. I believe one case is over a year old, and he was an addict at that time. He is currently doing Dawn Farms. He's doing it very successfully. He wishes to continue his treatment outside. If he cannot have a PR bond or home confinement tether, he wants to be released for treatment.
Robert Barnett stands before the court once again, his past chasing him in 2 case numbers. The defense fights for time, for videos, for one more chance to make it right. But the judge knows every delay has a cost. One case dismissed, one carried forward. The courtroom doesn't forgive easily. It only records the truth.
Thank you.
Will Your Honor consider release to treatment?
Pardon?
Will Your Honor consider release to treatment?
Certainly. I typically don't have an objection to somebody being released to treatment. So the only thing that you have to make sure, I would like a tether on that upon his release because of his failure to appear. And also that if he fails to complete the treatment, that he's returned immediately to the jail.
Absolutely.
All right.
Thank you.
Thank you. Court calls case People versus Emily Bates.
And Thornwater, Assistant Prosecuting Attorney for the People.
State your name for the record, please.
Nicholas Thomas.
Thank you.
Your Honor, I'm asking for an adjournment in this matter. Mr. Mayville and I are working to get a video issue ironed out, which I think we've resolved. We just need to get it over to my office.
Got it.
And then I'd like to address bond if I may.
Probable cause conference will be adjourned to November 20th, 2025, 9 a.m. Yes, as to bond.
Your Honor, my understanding, the current bond in this matter is a $10,000 bond that was set when Mr. Chalmers missed court back in early October. He's been in custody for 9 days since surrendering himself on that bench warrant. He does reside in Ypsilanti with his grandmother. His mother's here in the courtroom today to provide support to him. He does have a 5-year-old son.
The air turns heavy as the words released to treatment echo through the courtroom. Addiction, failure, recovery, all colliding in one man's plea for a second chance. The judge listens, weighing mercy against history. A tether, a warning, a promise. Freedom, but only under watchful eyes. Justice doesn't close its eyes. It just watches closer.
I got the days messed up. I'm sorry, Your Honor.
That sounds like a FedEx issue. You got the days messed up.
Yeah.
And he came back into custody because he turned himself
He
in.
did turn himself back in, Your Honor, to his credit. And like I said, he's been in custody for 9 days since then. I'd ask the court to give him another chance. This is the fourth PCC. To my knowledge, he had appeared for all prior ones prior to the one in October. And he's here today.
Yes, he is. Thank you, Mr. Bowman.
You're welcome, Judge.
Sponsoring the people.
Under the circumstances, I'm not objecting, Your Honor. The defendant has a very limited criminal history. However, what is on there, though petty, is from out of county and shows failure to appears on both of those files as well in his past. So I just wanted to make a note that eventually the courts are going to start taking note of that, but no objection.
All right. I'll reinstate his previous bond.
9 days in custody. A misdate. A broken routine. Now, a man stand before the judge, not fighting guilt, but fighting for trust. I got the days messed up, he says, and even the courtroom softens. The judge grants him another chance, but not without warning. Don't you dare miss again. Because in this courtroom, chances are rare and consequences are real.